In Illinois, criminal offenses are divided into two distinct categories. It's either a misdemeanor or a felony. A misdemeanor offense can have a range of several different penalties, but the penalty range can never exceed 1 year in the county jail, whereas felony offenses always carry the potential for a sentence to the Illinois Department of Corrections. Misdemeanors are divided into three subclasses, and those subclasses are Class C misdemeanors, Class B misdemeanors, and Class A misdemeanors. Class C is the least serious of the misdemeanor offenses, whereas Class A offenses are the most serious of the misdemeanor offenses. Typical Class A misdemeanors include DUIs, driving on a revoked or suspended license, batteries and domestic batteries, certain theft cases, and usually when someone is charged with a Class A misdemeanor, they're able to avoid jail time and even avoid a criminal conviction by being placed on what's called court supervision. Court supervision is a type of diversion program for misdemeanor offenses that allows the avoidance of any type of criminal conviction. Absent beating the case, getting court supervision on a misdemeanor offense is the next best thing. What supervision does is if someone completes the period of supervision, which is typically 12 months, without any difficulties, their case gets entered as a dismissal with no adjudication of guilt whatsoever. Felonies, of course, are more serious than misdemeanors, and in Illinois they're divided into 5 distinct categories. And those categories range from Class 4 felony to Class 3, Class 2, Class 1, to Class X. Class 4 being the lowest level felony, Class X being the highest level felony. Typically, but with some exceptions, Class 4, Class 3, and Class 2 felony offenses are probationable, with the court needing to presume that probation is the appropriate sentence for that particular person. And there are many circumstances for those type of offenses where there might be some type of diversion program available that will not only allow that person to avoid a jail sentence, but also a lifetime felony conviction. Class 1 offenses are sometimes probationable, but in many other circumstances carry a mandatory prison sentence, meaning that if the person were convicted of that offense, the judge would have no option but to send that person to the Illinois Department of Corrections. Certain sex offenses and certain drug offenses fall into this range. Class X offenses, being the most severe level felony in the state of Illinois, always carries a mandatory prison sentence. And the typical range of sentence on any Class X offense is a minimum mandatory 6 years in the Illinois Department of Corrections, all the way up to 30 years in the Illinois Department of Corrections. And in certain circumstances, that sentencing range can be extended. Also, in many Class X offenses, a person is not eligible for what is commonly referred to as day-for-day good time credit, where a person serves half their sentence. With Class X offenses, many of them, a person must serve anywhere from 75 to 85% of the overall sentence. In any criminal case, beating the case outright is, of course, always the best outcome. That will always depend on a variety of factors, including the strength or the weakness of the state's case, as well as the skill of your particular attorney. Short of beating the case outright, other strategies that can be successful are trying to negotiate a disposition to a lower level felony offense that has less severe consequences than the original charge, as well as determining whether there's any type of diversion programs that are available that would avoid any type of jail sentence, as well as avoid any type of lifetime felony conviction. If you are charged with any type of criminal case in Will County, Illinois, and have questions about how it is best to deal with your individual situation, please feel free to give me a call.